Appeal number 54, matter of Avella versus the City of New York. Good afternoon, Council.
Chief Judge DiFiore, and may it please the Court, Caitlin Halligan on behalf of Queens Development Group. I'd like to reserve 2 minutes for rebuttal, please. And I would like to focus my time on the public trust doctrine. The city, the state, and my clients all stand before you today because the stakes of this case are high.
Counsel, can you explain to me how Section 18-118, titled Renting of Stadium Flushing Meadow Park Exemption from Down Payment Requirements, how does that square with your argument about the plain language and the intent giving this, having allowed alienation of parkland for broad uses that are unrelated to the stadium?
Let me, if I can, Your Honor, first address your question about the title and then walk through the statute to explain why it accomplishes what we believe it does. With respect to the title, the immediate plan that motivated passage of this statute was absolutely, we agree, to allow for construction of Shea Stadium, but that was not the only goal that the legislature had. And so this court has held repeatedly that the title can't override the words of the statute itself. With respect to the statute itself,
The title's not irrelevant.
it's not,
The title doesn't say construction, it says renting.
the title is
So
not
it is about use.
well, use of the property itself. And what
Well, renting of stadium.
Your Honor, this court has held repeatedly that it's the words of the statute that control, and I'd like to walk through those if I can.
Well, before you do that.
Yes.
Because we're pretty familiar with the statute, but given your position that the purposes were obviously very, very broad, can you give me some examples of what would not be permitted?
Absolutely. You mean with respect to subsection B1? Subsection B1 requires that whatever the activity is be done for the benefit of the people of the city.
I understand that. Can you give me some examples of what would not be for the benefit of the people?
Yes,
of
so
the city
something
under
that
your-
was only serving a private purpose, for example, a private club, for instance, might be a facility that was not something that was within the broad purposes.
So then why wouldn't the statute say that it could be used for any, why give all these examples? Why not just say it could be used for any purpose except for a purely private purpose that excluded the public? Wouldn't that take care of it?
I think that if the legislature had wanted to write a statute that simply authorized the use of a stadium, we know it would have done so, but it would have done so differently. I would urge the court to look at the Yankee Stadium statute. Section 2 of that statute provides for the use of attractive land for development of a professional baseball stadium and related facilities. That's how the legislature drafts language that it means to be used only for that sort of a specific purpose. What it did here was very different. I think it's also important to look at the context.
All right,
in
well,
it.
let's go with your argument and your description of what wouldn't be covered. I'm not clear why a mall doesn't fit into what wouldn't be covered.
For several reasons. It undoubtedly serves the public purposes set forth in subsection B. I would argue
What's that? I'm sorry, what's that purpose? What's the purpose?
far more than a stadium would, Your Honor.
No, but what is the purpose?
First of all, it is the catalyst, the economic engine for remediating Willets Point. The other projects that were proposed here required prohibitive public subsidies. If you look at page A580 on the CD-ROM, the other proposals required between 260...
Well, okay, so let me get that argument. So you're saying in 61, the legislature alienated parkland to be used for any purpose that allows the city to clean up an area. Is that the argument?
My argument is that it alienated it for any purpose set forth in B. That does include...
Because I think you're back to then nothing is excluded, because wouldn't anything on that property bring some benefit to the city? Maybe it's cleaning up the area, maybe it's taxes, maybe it's something else.
The legislature is certainly allowed to write in very broad terms when it alienates parkland. There is nothing in the public trust doctrine that suggests that it cannot do that. And this court, as it did in Bates versus Holbrook, as it did in Brooklyn Park, the only two cases looking at parkland that actually involve a statute that alienates land, simply analyze the terms of the statute itself, and that's what we
let me
would
ask you
urge
this,
you to do here.
Counselor, is there a reasonable interpretation of what the legislature did in which the legislature didn't alienate parkland at all, but simply declared that the stadium and appurtenant uses were a park use? So there's no alienation here.
I don't believe so for two reasons. First of all, Your Honor, if you look at page A638 of the bill jacket, what the House memorandum provides is for the establishment and maintenance of facilities, not just a stadium, which provide for recreation and entertainment. So it's clear that there was an anticipation that the city would have the authority down the road to decide how to use the rest of the land. The second piece is the context of the statute. If you look at subsection C, there are 77 acres that are alienated there. Shea Stadium took up about 15 of those acres. The legislature drafted A, which allows for the city to enter into an agreement with any person for a wide range of uses to serve the wide public purposes set forth in B, because it understood that a large part of that tract that it was alienated had not yet been, the use of that had not yet been determined, and it allowed the city to take care of that going forward.
How do you explain B2? Because subdivision B2 talks about business and or commercial purposes. But it requires that they be related to the financing of the
Yes, Your Honor.
stadium. So what is the difference between this retail shopping center that you say falls under B1 and something used for business or commercial purposes that are only allowed under B2 if they're related to the financing of the stadium?
Yeah.
Doesn't your interpretation make B2 completely superfluous?
No, and let me first explain why the Willits West Retail and Entertainment Center does serve the purposes in B1, and then address B2 if I can. Willits West will not only enable, finally, after almost 100 years, the remediation of this land, but it also will serve public purposes unto itself.
Okay, that assumes that it doesn't have to be pertinent to the stadium, right?
Well, I believe that there is no question that it has been exceedingly difficult to reach any agreement to remediate this land, and the fact that this allows that to go forward is a public benefit. A distinct question from whether it's authorized by the statute, yes.
Okay.
But it is
Fair
a
enough.
tremendous public benefit. Willits West alone as well provides substantial public benefits, not only in terms of jobs and in terms of tax revenues.
Counsel,
and
no
in
one
terms
is debating it might be a great idea. That's not the point. The
Public
point is whether or not
safety
you
as
can do it
well.
in the park. Because of course, those developers could find private land and pay for it and put up their hotel. That's not the question. The question is whether or not they can try and do that in the park.
Well, to be clear, it's a parking lot right now. It's not green parkland. The question, I agree, is whether it
No,
falls
but it-
within the framework of the statute.
Can we turn just for a second? Because it seems, in my mind, it's purely a question of statutory interpretation.
Your Honor.
And I'd like to narrow it down to whether or not you think we should be applying the principle of a justum generis. You know, phrases are known by the company they keep, for those of us who haven't taken Latin in high school. And on top of it, if so, if we're applying that principle, then in this context, is there any part of the statute that wouldn't relate to the interpretation of the phrase, the general public benefit phrase? Because there's some argument about whether or not you read the types of activities that are outlined either before or after the key phrase in the statute. So,
Yes, Your Honor. So what the legislature did here, as you suggest, is to identify a number of broad purposes. Then it used the word including, which this court has held does not limit what comes before it, but suggests that what follows will be illustrative examples. And that is what follows, and it's unsurprising that
But
those
how does
examples...
the retail park, shopping center anywhere similar to any of those items that are listed, other than, as you
My
say,
point,
it's
Your
for
Honor,
public
is
benefit?
that it need not be, and here is why. Because those examples are illustrative of the types of activities that can fulfill those purposes. It's not
But again,
surprising.
why give any examples at all?
Because-
If all that matters is that it's for a public purpose.
Again, because what was the immediate plan was to build the stadium. So it's unsurprising that the legislature would have given examples which themselves are extraordinarily broad. They encompass any activity I could possibly contemplate taking place in a stadium. But because that was the only immediate decision that had been made, and the determination about how to use the rest of the land had been deferred, those were the only examples that they could have provided. Again, the
Well,
Yankee Stadium
They
statute.
could have given different examples, though, just to follow up on what Judge said. They could certainly given examples that lean towards more improvement of trade and commerce, which is the phrase that you're relying on, and they don't seem to do that.
Well, I think some of them do, meetings, assemblages, that sort of thing. But in any event, the appellate division said that the first part of B1, the broad purposes, was, as it put it, unquestionably wide. That is right. And what you would do if you allowed the list of examples to control the meaning of those broad purposes is, first of all, you would really run afoul of this court's canon of interpretation about what the word including means. But more importantly, you would write those broad purposes out of the statute. And I think that it's important to make the point that there's nothing about the public trust doctrine that ties the legislature's
I
hands
suppose
that
the
way.
question really is then, it is whether we're writing those broad public purposes out or limiting those public purposes by the examples.
And again, Your Honor, I'd urge you to look at the Yankee Stadium statute where it says for a professional baseball stadium. Thank you.
Thank you, counsel. Counsel?
May it please the court, Richard Deering for the city. Just to piggyback on this adjustum generis or nocitur associae point, and maybe expand upon it a little bit, is if you really look at this phrase that begins with including and then lists a series of events, happenings, et cetera, and that phrase itself ends with a catch-all and other events of civic, community, or general public interest. And I think this really shows why Ms. Halligan's point is powerful. That phrase would stay, if you read that phrase as limiting of the broad purposes, that phrase could stand entirely on its own, and you really should take a pen and strike out the 46 words that preceded from the right after the word for on
But it
the.
says an event, doesn't say a mall.
But the point being,
How is an event a store?
well, an event is not a store,
Okay.
but a mall fits within several of the broad purposes that precede this including phrase. And I do want to try to wrap up on that phrase. If you struck the language of the statute beginning with the word for on the second line of Respondent's Appendix 1077, all the way through the word including, you would substitute this list of events, the ending with and other events, as the controlling language of the statute. That's 46 words you would cut out of that statute. And we know whatever these canons mean, they don't mean that you're supposed to write out 46 words that the legislature chose to put there. And so now returning to what those broad purposes
I'm sorry,
say-
how are you suggesting to read this? What is it you're saying can be ignored, or am I
No,
misunderstanding your
not to
point?
ignore it. I mean, obviously, things that fall within that including phrase are within the scope of the statute, but that doesn't mean that those broad purposes that precede that including phrase should be ignored. And just
Well, it
to-
just strikes me, so everything after that comma, everything after including is events of some sort.
exactly my point, and
Right, again, it's not a structure like a mall.
not that phrase, and that's where the appellate division really went wrong. It focused on that phrase to the exclusion of the broad list of purposes that preceded it, and that's really treating the statute as if the legislature in B1 had just listed those events rather than including
But
those broad
gi-
purposes
Given
for
this
it.
language here, which you say is very, very broad, don't we have to interpret it in a narrow sense? Interpret the broad language narrowly when we're referring to the public
No,
interest
the
doctrine?
statute should be interpreted, as one of your honors said, it's a straight question of statutory interpretation. We should effectuate
But
the
we're talking
legislature's
about the
intent.
public interest doctrine.
But there's no, but
It's
public.
not just any statute,
Sure,
it's
but
a-
the
it's a
court's
statute
cases have never.
pursuant to that doctrine.
Understood. The court's cases have never focused on a case that, the situation where you're trying to interpret the scope of what is admitted by everyone to be an alienation statute directed at a specific parcel. So really the question direct and specific is satisfied here. There's no question it's directed at alienation. I mean, a lease is authorized. The question is which leases. And it's no question it's directed at this specific parcel. It's direct and specific. Once you have the legislature having called its mind to that question, the words they chose to use should be interpreted like any other statute. And just to kind of elaborate on
Could you move the mayor's residence to this
No, I
parcel?
think a private residence
not?
is an excellent example. A private residence, even of a public official, is an excellent example of something that wouldn't fall within the scope of B1. And it's important not
Could you move the
to,
Department of Motor Vehicles to this property?
I doubt that you could.
Why not? Isn't that for the public benefit? I mean, some people might disagree about the DMV, but let's assume
let's-
so.
Your Honor, it doesn't stop at public benefit, and let's just to go through it, recreation, entertainment, amusement, education, cultural development or betterment, and improvement of trade or commerce. What we have here
Let's say
is,
you open up the mayor's residence for tours. Could you put it on this property?
doubtful, but this is quite far
Well,
from that.
why? This is
Because
what I'm asking.
this-
Why?
This development resonates with several of these purposes.
But
Entertainment, amusement.
but if what you wanted to do only resonated with one, wouldn't it satisfy the statute? Does it have to do multiple purposes?
Perhaps, but well, let's sort of, for this purpose, let's skate over the language a little bit and identify some points of similarity that I think have been overlooked by petitioners here. The retail center sitting right next to this stadium, both of these are public spaces, both of them are public attractions, both of them are public destinations. The public will visit and stop at the 7 train right there, the LIR, and visit both of these things. It's not hard to imagine, as we've pointed out, somebody before or after a game going to this retail center, someone in a family or a group of friends who decides, I don't want to go to the game, or maybe the game gets out of hand early, decides we're going to go spend time there. There is symbiosis and complement within these two uses.
No, we can clearly see the economic viability of the project, but that's not really our question here. Our question is really in some ways broader than that. Does your reading of the statute create a situation where parkland that is alienated for a specific purpose becomes free to be used for any purpose? And
No,
that's
it's gotta be within the
I'll
terms-
slow down.
Sorry.
But that's the question that we confront, and I think that's where the questions that go to the heart of what the public interest is here can't be ignored. That's why we get back to what was the statute about? What was it aiming to do? It was aiming to provide a home for the Mets.
Sure.
That's what we're aiming to do here. Now, how far askew can you go in that pursuit of the home for the Mets? And when does it become private interest and not public interest? And that's why this list becomes very important to our interpretation.
Understood, and I think it's important in that vein that it's understood that this is a place that the public comes to and uses. It uses for a movie
But you see
theater.
the distinction. The public comes to many private activities perfectly appropriately, and this, I no doubt that this would be a good thing for the neighborhood, but that's not the same as saying that it shouldn't be treated as alienation of parkland with limitations on it.
And that brings me back to the question that I had asked earlier about, given your interpretation, what is the need for and significance of B2?
B2, it refers to purely commercial activity.
But how
that does
how
not.
is this not that?
Because, well, this touches on several of the purposes, including at the end, just to go to the heart of it, improvement of trade or commerce, which is a term of art that is not
Why
synonymous.
wouldn't every business, I think is Judge Stein's point, satisfy that?
I don't think so. And in that vein, the Sunco case, the Kaufman's Carousel case, both cited by the petitioners that talk about major retail development projects as sort of a game changer in the area. That's improvement of trade or commerce. That is not the same thing as just garden variety trade or commerce. The
So
two
one
terms are
store
not.
coming in here would not be improving
No, I
trade
think
or
that's a
commerce.
good example. Just a simple retail use, garden variety retail, does not rise to the level of
So
improvement in trade.
B2 allows that one store, but B1 doesn't? Is that what you're saying?
B2 could allow a simple commercial use that doesn't rise to the level of improvement or trade and commerce, as long as the money is used to
But
finance
what's
or
the
operate the
definition then
stadium.
of improving trade or commerce? How would we apply that for the next business that
There's
comes?
case law, we're talking about this statute, and it's really only this statute that we're talking
So
about
under
right
the
now. But there are
statute,
cases.
how would you define
There's cases, and I would
improving
follow what the Fourth Department did in those two cases I just cited, which are about, they're in a slightly different legal context, but still relevant. They're about use of eminent domain authority, what is a public purpose, and they understand that certain types of retail developments that are for economic redevelopment, truly for economic redevelopment, revitalize an area, those rise to the level of improvement of trade or commerce. And things that don't, this case is easily on that side of the line. Other pure retail or commerce, straight advertising, billboards, things like that, that don't rise to that level, I would say do not fall within B1. And if they're going to be, if they try to, were tried to be brought in under B2, they could be, that could be done only if the
There are
money
like
there-
10 little stores without the roof in one building that's connected, and,
No,
you
I
know,
think
people
that-
are not going to get rained on when they're walking around.
I think that's an easy case. It doesn't get there, and that's
No,
not
no,
the,
but what does that mean, it's an easy case? Is it fit under B2 or not?
if the money, it could be brought under B2 if the money from that, those operations were funneled back into the operation, the construction or financing of the operation of the stadium, and that's what the terms of B2 say. But B1 and B2 are independent grants of authorization, and this case is clearly within B1.
But couldn't one business, and we've seen this in other contexts, one superstore come in and make the same claim that it's a redevelopment project? We're going to lift the neighborhood because we're going to employ X thousand employees at minimum wage here, and this is good for everyone. It's an improvement of trade or commerce. We're too big for you to not let us fall under this provision.
They might, I think it would be within the judgment of the city officials who administer this lease, whether that standard is met, but, and the court obviously to review that, but I want to just return to a key distinction, and this is a distinction that gives the court a narrower path to resolve this case. It doesn't require it to go that far, which is this is a public attraction. This is not just the DMV, it's not just a private residence, it's not just some office building. It is a public attraction. It's a large public space. There's public programming there.
What
There's a-
happens when all these online companies put all these super malls out of business? Then what happens? Then we're going to be dealing with another empty structure on this parkland? Is that it?
Well, let's hope not. I mean, folks will have to adjust if it comes to that. That's certainly.
Counsel, if we were to reverse on statutory interpretation, what becomes of the remaining land use issues? Do they get remitted back?
The remaining land use issues are not before the court, and they've been waived jurisdictionally because no cross appeal was taken. And let me thank you for bringing me to that point, because I want to try to unpack a little bit why that's so. And the first key question is were the petitioners here aggrieved such that they were required to cross appeal? The test of aggrievement under their own case, the parochial bus systems case, did the petitioners get all the relief they sought? Now, the simplest way to understand that they didn't is to go here to the prayer for relief set forth in the petition. That's A 56 to 57 of the appendix, where the petitioners set forth distinct, highly specific and distinct relief under 4 different subparagraphs for each of their causes of action. And the appellate division here, almost verbatim, not quite, but almost verbatim, copied the first subparagraph and granted the petition to the extent, in their express words, of affording the relief on the first cause of action. But the petitioners here sought 3 distinct and separate declarations, 3 distinct and separate types of injunction, and they only got one of those 3. And that meant they are in fact aggrieved. They did not get all the relief they sought, and they needed to cross appeal to raise those claims. And just a thought experiment to put a finer point on it is, if the appellate division's decision had become final, if there had been no further proceedings, and after that decision had been entered, a new statute, it's not required as we've argued, but just hypothetically, a new statute had been passed by the legislature explicitly saying we authorize Willits West, the petitioners would be out of luck on their argument that they needed a ULURP, they needed a rezoning, they needed further action at the local level. They didn't get that relief, and they would be stuck. None of those steps would be legally required to be taken. They had not obtained that relief, and that's the easiest way to see that to raise those claims, to continue pressing them, they needed a cross appeal. They didn't do it. The claims aren't in the case anymore.
Thank you,
Thank you
counsel.
very much.
Thank you, Your Honors. Anisha Dasgupta for the State of New York. I'd like to start by addressing some of the statutory interpretation questions here. I think we're rightly focused on the purposes that are set forth in Subdivision B, Clause 1. Now, the state very firmly believes that the legislature has to provide direct and specific approval plainly conferred to use parkland for non-park purposes. But it's the state's view that that authorization has been provided by this statute. And if I may, I'd like to walk the court through why that is, looking specifically to the provisions of B Clause 1. I think we all agree that that's the clause that governs this case. Now, the first reason why this is a public purpose has to do with the nature of the contemplated project. We've all been referring to it in shorthand as a retail shopping mall. But it's not the state's interest here to come and promote a retail shopping mall. The Office of Parks has determined that part of the reason why this development is consistent with the public trust doctrine and authorized by the statute is that it's going to provide recreational opportunities and open space to people in this community. So the complex that's going to be developed at Willits West, in addition to what we've been discussing with a retail store and a movie
I'm
theater,
sorry,
also
I just don't understand that point. So as long as it's providing open space and it can be any use, or how do we read the public use doctrine through that filter? I mean, would that apply to the Adirondacks? So that you could build a shopping mall, but there's going to be a lot of space? I don't understand that argument.
Well, what I was going to say, Your Honor, it's the other components of this redevelopment project. So this project is going to provide public program space, an outdoor plaza that's going to be available to the public to accommodate unscheduled gatherings and scheduled
primary-
events that are going to include museum
Primary thing
exhibitions.
here is a retail space.
Excuse me, Your Honor?
That's the primary purpose of what you want to build here, or what they intend to build, right? It's a retail space.
The
They're not
proposal,
building a public performance space here.
well, the proposal that the city put out for developers to come up with a plan on wasn't simply a shopping mall. It was a space that provided different kinds of places for public engagement. So we have this outdoor plaza space where, according to the permitting documents, there are going to be
But the
museum
proposal
exhibitions.
wasn't to build an outdoor space and then have a few stores around it. The proposal was to build this retail shopping mall.
That's true, Your Honor, but it's going to have, for example, a rooftop farm and greenhouse that's going to be open to school groups and community organizations free of charge. People are going to have the opportunity to go there and to learn about gardening. So
But
when we look at
isn't
the
this really-
purposes,
Shouldn't we be really looking at it and say, what's the primary purpose of this activity? And the primary purpose of this activity is not to, it may, in an ancillary way, provide some kind of, tell you what food to buy, what's the right thing to buy, all just perfectly legitimate public purposes. The primary purpose of the activity is a private purpose. It's to lease space, to set up a shopping mall so people will spend money in the context of coming to other sporting events. Those are primary, legitimate, profit-making motives. The primary purpose is not anything else. And ultimately, if we look to the heart of it, aren't we restrained by that analysis to require that this particular development be approved by the legislature?
again, this statute does approve the project because, for example, the language of B1, Your Honor is talking about primary purposes. B1 doesn't use the word primary, it uses the word purposes. And the different functions that this space will serve a number of the
So that's
purposes
your
set forth
response.
in
We
B1.
shouldn't look at the underlying purpose of the statute. We're restricted then to the word purpose, not primary purpose.
The court should look at the text of the statute, and the statutory text
Yeah,
uses
but
the
the
word
text says any
purpose.
purpose or purposes which is of such nature. So there is some limit. You can't really just say purpose.
That's exactly right, Your Honor. There are important limits. The appellants and the city have already discussed some of the limits. I think one important distinction.
And don't we have to contextualize those limits with respect to the point, the whole reason that the state allowed the city to use this land? It was to build that stadium, pertinent lands and these facilities and the parking space. And that's the way you look at the statute in the context of what the state was looking at, what the city wanted to do, which was to build this stadium.
Well, I'd like to respond to that in two ways, Your Honor. The
You're not
first is
really
that
arguing that the legislature anticipated building a mall next to Shea.
It doesn't have to do with the mall. What it has to do is, the question really for this court is, did the legislature contemplate only the construction of a stadium? or did it intend the land to be used for some purposes that were potentially broader? Now, that's not every purpose, because as the court has pointed out today,
Surely that's a
there are
compelling
limits.
argument that it's not only the stadium, because of course it's referring to
Other
appurtenant grounds and facilities, agreed.
Well, the word, Your
Question
Honor,
is, what can you use that for, given the language of the statute, and given again that the point of the alienation was to build this stadium, to draw people into the stadium?
well, again, 2 points, Your Honor. First, that the legislative history of this statute is broader than that, and in contrast with other stadium statutes. So, for example, the bill jacket here, the memorandum supporting the Assembly bill, and this is at appendix page 628, when it's referring to what the legislature contemplates in terms of public purpose, it says, it's served by government action designed to effect the establishment and maintenance of facilities that provide entertainment and recreation for the public, promote public health, afford meeting places for gatherings, furthering the enlightenment and education of the public.
But
So that
everything that's listed in the including phrase refers to things that would generally take place in a stadium or connected to a stadium. And to me, that is the overriding theme of this legislation in the first place. And so it seems to me that going to a retail shopping mall is a real leap. It's not just a plain reading of the statute as you suggest.
well,
And if I may add, the operative word here is events. And what you described still sounds like a bunch of events. Now, they may have longer periods of time that they exist. You may have a cultural series of performances, but they all still sound like events, not a big mall where people can go and shop.
Again, the state resists the characterization of this project as exclusively a mall because it's the conclusion of the Department of Parks that it is going to provide some valuable public spaces. But to Judge Stein's question, yes, as the First Department noted, all of the purposes here could be seen as things that would be served by a stadium. But they need not be. And the legislature knows how to write that stadium limitation. The Yankee Stadium statute is a particularly illustrative example of this. So in the Yankee Stadium statute, the legislature talks about Yankee Stadium and other facilities. But every time it talks about those other facilities, it uses a relational term, like related to, associated with. Here, we only have a relational term once. That's the word appurtenant in the first sentence of subdivision A, which refers to initial agreements. The second sentence of subdivision A that talks about subsequent.
Better if the statutes were flipped, right? If the Yankee Stadium one came first and they didn't include that in here. But what year is the Yankee Stadium statute?
2005, Your Honor.
Right. So by that time, there was a lot more of an understanding. People were going to do this kind of thing at all. So I think it's hard to make that argument with the statute that you have in the early 60s and then one that's made in 2005. But going back to your interpretation of the public trust doctrine, it really seems that the state's view here is that if it's worthy, then it's it kind of overrides the public trust. Because while this is primarily a retail facility, it has some good things in it.
Not so, Your Honor. If the other functions of this project did not serve the purposes that were set forth in B1, the state would not be here today. Because, of course, the state is a custodian of parkland, and it's the state's interest to make sure that parkland isn't being used for non-park purposes that haven't been authorized by the legislature. So we wouldn't be here today. But to return to one small point about the Yankee Stadium, and then Your Honor's question about the chronology. So the Yankee Stadium statute, when it sets out purposes, talks about these as being things that the stadium, quote, will provide. So in the Yankee Stadium statute, the purposes are expressly linked to a stadium in a way that they are not in the language of the statute. Now, of course, the Yankee Stadium statute is 2005. The statute is 1961. But we do have an example of a statute that's not too far removed from this statute in time. That's the Erie County Stadium statute. That was enacted in 1968. So roughly at the same time as this statute. And again, the language of that is instructive because that statute, like this statute, talks about broad purposes in ways that are associated with a stadium but not necessarily purely served by it. So in the Erie County Stadium statute, the legislature refers not just to the stadium, but to the site of the stadium. Now, that is analogous to what's happening here, where the legislature refers not just to the stadium itself, but it refers to the parking areas, other facilities, other grounds. Now, we have these statutes on one side. To the other side, we have the Yankee Stadium statute and the U.S. Tennis Association statutes. The state thinks that those are very good examples of how the legislature can very clearly express its intention to limit particular purposes only to stadium purposes. So the Yankee Stadium statute, again, not only includes those relational terms, but its statement of purpose is all about the stadium. It's all related to the stadium. In the U.S. Tennis Association statute, when they talk about purposes other than stadium and tennis purposes, they limit those purposes to 1 year in duration. They say, if you're going to use this for non-tennis purposes, your lease is limited to a year and can't be renewed. Now, this 1961 statute that we're construing here today, it doesn't have any of those hallmarks at all. And I think the message of this is that the legislature sometimes speaks in broad terms and sometimes in targeted terms, but those distinctions have meaning, and it's the task of this court to give effect to the meaning. The state has been advised that this is going to serve the purposes in B1, not just through the development of the Willits West site, but also through the cleanup of Willits
Even
Point.
assuming your reading is correct and about the stadium and Yankee Stadium, the differences in all Erie, it's still, even under your interpretation, would have to fall within one of the purposes of B1.
That's right, Your Honor.
And in your view, that the purpose that most closely aligns with this is to the improvement of trade and commerce? And do you agree with the statement that these are game-changing type commercial facilities?
Improvement of trade of commerce would be served because of the spillover from this commercial facility, but that's not the only
That kind of
purpose.
cuts- That a little ways cuts against your parkland and the thing on the roof argument, right? Because really the improvement part of this is the nature of the commercial space.
But that's not the sole purpose. So here, the purposes in B1 include recreation, entertainment, amusement, education, cultural development, and the improvement of trade and commerce. And as this project has been described in the permitting document, that the different components of the project will satisfy those different spaces. So of course, the retail, movie theater, and entertainment venue aspects are going to provide recreation and entertainment and amusement. There's the public plaza space, which is going to provide gathering space, the rooftop garden, which is going to be used for educational purposes, and then the retail complex as a whole, which is expected to improve trade and commerce in the area by bringing jobs. I mean, certainly this would be a far closer case if the only purpose we were talking about was improvement of trade of commerce, although those words are in the statute. I mean, I think it
But
is
they didn't have
important
those
to-
other things, but just had the movie theater. Does it satisfy your definition? Just the movie theater.
if they
Got
were
a bunch
just
of
building a
stores
movie theater
and
on the space.
huge movie theater. Does it satisfy your definition?
That would seem to be something that would provide recreation, entertainment, and amusement.
Thank you, counsel.
May it please the court, my name is John Lobear. I represent, excuse me, petitioners, respondents, many of whom I believe are here today. I would submit that the focus of the discussion so far has been a little bit off the mark, and that the structure of, if you look at the overall structure of this statute, you really need to look at subsection A, not subsection B. Subsection B is really a parenthetical to subsection A. Subsection B has nothing to do with what can be constructed on the site. And this whole discussion about nocitur associis or eusdem generis or what these purposes actually are is It's important because that is just further evidence that this subsection B has nothing to do with construction. The only reason that subsection B is in this statute is to make sure that this stadium would not violate the state constitution, Article 8, subsection 1. And,
The argument is they can't build anything on the lot? Is that what you're trying to say?
well, nothing other than a stadium and appurtenant facilities, yes. And if I may, I'd like to just,
So if they wanted to build a dance theater, could they do that?
no, they could not.
Even though it serves the purposes of amusement and whatever else?
I would submit that those purposes have nothing, again, have nothing to do with what can be constructed there. They only have to do with the manner in which the stadium and its appurtenant facilities can be used. And in fact, even the phrase itself, it says that the lessee may occupy or may use, occupy, or carry on activities in the stadium. And my adversaries repeatedly, over and over and over again, they cite this list of purposes, and then they say that these purposes are for the use of the site, or Willets West, or the land, or the subject property, or the parkland, anything to avoid the use of the dread word stadium, which is the one that's in the statute. What the statute says is that these are purposes for which the stadium and its appurtenant facilities can be used. It doesn't say that these are purposes for which the property or the site or Willets West can be used. I mean, under their interpretation, you could demolish the stadium or perhaps even never built it in the first place. But anyway, why not demolish it and use the site for something else?
So there are stores there selling Mets merchandise, right? Are those, there are stores there now selling Mets merchandise. Are those appurtenant uses?
Well, some of those stores presumably are I'm not sure what stores there are, but under Section B2, a certain commercial activities are allowed in support of the operation of the stadium. So if they sell Mets paraphernalia, yes, that's...
My question, I guess, really is, do we have to look to see what the retail stores are selling to determine whether they're an appurtenant use? Or can it just be a shopping mall that maybe sells some Mets merchandise and some other stuff?
No, I don't believe a shopping mall can be considered appurtenant to a stadium. Appurtenant to means that it's necessarily related to it. It serves the stadium. It doesn't mean a wholly separate thing, which even though the city has argued that...
Let me just take a step back here
Yeah.
on your analysis, because what you're saying is, the way I read the statute is section, or subdivision A is the enabling legislation, subdivision B sets out the purposes. And that after it's enabled, the purposes are illustrated in subdivision B, but they're still restricted by the language in the enabling legislation. So whatever is in B, is this your argument? It doesn't matter because A has already limited them.
Yes, A has said that what you can construct...
Which goes back to what Judge Wilson was saying, in essence, that the proposed activities by the city are not appurtenant to the stadium development.
No, they are certainly
So
not.
that's your point. So that whatever is in B is necessarily limited by the appurtenant language in A.
Yes.
Do I have that correct? Okay.
Yes.
All right.
And if I may, I'd just like to read subsection A. I've omitted nothing of any relevance, I don't think. In a nutshell, here's what it says, and I think it's very clear. The city is authorized to enter into leases with any persons whereby such persons are granted the right for any purposes referred to in subsection B to use, occupy, or carry on activities in a stadium with appurtenant facilities to be constructed by the city in Flushing Meadows Park. So in other words, the city will construct a stadium, it can lease that stadium, and then the lessee can use that stadium for any of the purposes described in subsection B, the stadium, obviously, and its appurtenant facilities.
Well, it says
Shopping-
appurtenant grounds.
Sorry?
It says appurtenant grounds, so wouldn't that be all the land that leads up to the stadium?
Well, grounds.
Then we're back to why is it they can't construct something on those grounds that satisfies the purposes of B1?
Well, they cannot because the term because construction occurs 4 times in this statute, always with reference to the stadium and the appurtenant parking areas, grounds, and other facilities. Grounds refers to landscaping, things of that nature. I don't think it refers to a shopping mall. I mean, the notion that the word grounds.
What does improvement of trade or commerce mean? What does that mean?
What does that mean?
Yeah.
Well, I have argued in our briefs, we argue that improvement of trade and commerce is a term of art that denotes a public purpose for example, it would include trade fairs, exhibitions. In Bordelot versus the state of New York, this court held that promotional, sort of an advertising campaign, I believe for the wine industry, for the state as a whole, constituted improvement of trade and commerce, and therefore it was a public purpose that could be legitimately funded by the state within the parameters of the constitutional limitations, but it wouldn't include building a private shopping mall.
Did you argue anything about Article 8, Section 1 of the state constitution in the courts below?
Yes, it's been, it was argued both extensively in the Supreme
It
Court.
doesn't seem to be focused on very much in the briefs here.
Well, I do have a section on that, and I believe it's the key to this statute, actually, and if I may spend a moment explaining why, I'm happy to do that. I believe that this statute, this statute was drafted to meet the requirements of 2 overarching laws. One is the public trust doctrine, which, as the state stated in its brief in Capruso, requires that the legislature directly authorize the specific project in question. I think the state was absolutely right there, and I think, that could be the end of this case right here, because I don't think you can say that this statute specifically authorizes the project in question. But in addition, the gifts and loans provision of the Constitution is really the key to this case. I would direct the court to this statute was passed on a home rule message from the city of New York, and there is a memorandum in the bill jacket which extensively discusses the question of whether city financing for a construction of a stadium is a public purpose or not. And it concludes that if the uses of the stadium are limited to certain public purposes, then it would pass constitutional muster. And this is the reason why not just this statute, but also the Yankee Stadium statute, the tennis stadium statute, and the Erie County Stadium statute all have similar, if not in the tennis stadium case, virtually identical word for word purposes provisions. If you interpret this provision to mean they can build a shopping mall, then why can't they build a shopping mall in a second shopping mall in Flushing Meadows Park where the tennis stadium is? And if it doesn't if that's, I mean, under my adversary's theory of the case, why are these purposes provisions put in the first place? What are they doing there? They don't really have any reason why the legislature, in enacting all of these stadium statutes, would have included a list of public purposes. The reason is that they were looking to the Constitution, Article 8, subsection 1, and they said, well, in order to avoid a constitutional challenge, we need to include this provision. And there's extensive case law around the country on whether public financing for stadiums is constitutionally permitted under the gifts and loans provisions that virtually are present in the constitutions of virtually every state. And there's another way, too, in which the gifts and loans provision of the Constitution guided the structure of this statute. This stadium, Shea Stadium, was to be constructed with city financing. So again, Article 8, Section 1, required that it be that the construction be done by the city, and that's why it specifies anytime it talks about construction in those 4 places, it's clear that the construction is to be by the city, not by the lessee. The lessee can use what is to be constructed by the city, but at that time, vehicles like the Economic Development Corporation or the Urban Development Corporation, which exists to circumvent the strictures of Article 8, Section 1, didn't exist. So now, I mean, we're not arguing that this provision is unconstitutional, but because it doesn't involve city financing, and anyway, it's being done through EDC. But the state, even today, cannot itself directly finance the construction of a structure for private use. So anyway, I'm sorry, I
Thank you.
ran
Quite all
over
right.
my time a little bit.
Thank you.
Thank you very much. No more, no, okay.
Thank you, sir. Is the gifts and loans provision of the Constitution the key to the case?
Absolutely not, Your Honor. First, as Mr. Lobert himself acknowledged, there is not a gifts and loans challenge that is brought here. It couldn't be for the reasons we laid forth in our brief under Board Low. One of the purposes here in enacting this statute was likely to ensure there were no gifts and loans concerns, but it was only one of the purposes. Alienating this land was the other reason, and you need to look at the text of the statute. I'd like to make 3 other brief points if I can. First of all, Judge Fahey, you said your obligation is to protect the public trust doctrine. We understand and we agree. First of all, this statute is sui generis, and so there's no concern about spillover to other statutes. And secondly, we are not arguing that you don't need legislative approval to use a park for non-park purposes. We are saying that the 1961 statute provides that. Secondly, Judge Fahey, you also said this is a question of statutory interpretation, and we agree with that. The only coherent construction, if you look at the full 77 acres alienated in subsection C, is that the city was given discretion to decide what to do with the other 60 acres after Shea was built on 16 of them. And Mr. Lobert's construction of the statute would deny the city that leeway. Third, the construction of subsection A. First of all, Mr. Lobert, in his brief and in his argument, has entirely ignored the second sentence of subsection A, which begins with prior to. It does not tether the authority of the city to enter into agreements for the purposes in subsection B at all to the stadium, appurtenant grounds, parking areas, or other facilities. So that sentence standing alone would allow the city to enter into the agreement, and we ask the court to look closely at that. Additionally, the
Counsel,
terms...
before you get to the additionally, on your sui generis point, isn't part of Judge Fahey's point, I think, that we're applying a doctrine here, and yes, it's to a specific statute, but it's the approach we're going to take in applying that doctrine and how narrowly we read the words that's going to be cited back to us later. So yes, this is its own thing, its own statute and its own interpretation, but really what we're talking about is the public trust doctrine and how do we interpret that statute. So that's what's going to have precedential value.
Two responses to that. My point about it being sui generis was simply that I think that Mr. Lobert suggests that if you rule in our favor, that automatically consequences will follow. Other statutes are not written in the same way because, as the lawyer for the state explained, they constrain the uses very carefully. With respect to your point about how to approach the public trust doctrine, there is no support in the precedents of this court to expand the public trust doctrine in the manner that Mr. Lobert suggests. He indicates that there is some sort of a clear statement rule you should derive. This court has instead simply looked at the statutes to effectuate the intent of the legislature and not brought a
What about the
presumption to bear.
plainly conferred language of those cases?
What that means is that there must be an explicit alienation as opposed to simply using a park for non-park purposes. So, for example, when this court
I'm
in
not sure I
Van-
follow that. I'm
So in Van Cortlandt Park, for example, which is a case that Mr. Lobert heavily relies on that does use this language, the question there was whether or not a temporary underground use of a park was sufficiently intrusive to still require some legislative approval. And the court said, yes, it must be plainly conferred. The phrase has its origins in Williams versus Gallatin, which is a case from about 100 years ago where Judge Pound said, if you're going to put a museum on a park, you need legislative approval. It has to be directly and plainly conferred. There are no cases from this court suggesting the kind of canon that he would propose. Just to finish my point about subsection A, if I can, the activities that are authorized by the plain words of the statute are much broader than construction. They are to use, occupy, or carry on activities. Additionally, the kinds of agreements which the city can enter into plainly contemplate a wide range of uses, not just construction. Contracts, leases, rental agreements, licenses, permits, etc. So that narrow construction simply is belied by the statute itself.
Well, they all talk about events, right? Does that somehow suggest that perhaps it's not about the construction of a permanent edifice that ends up being a retail space?
No, Your Honor, I think not, both because that language is so broad, because it doesn't account for subsection B, which has no restrictions, and because this...
No, well, B, it does say events. That's
Sorry,
what I'm
the
talking
second
about.
sentence, pardon me, Your Honor.
No.
The second sentence of subsection A is what I meant to refer you to.
Okay.
And finally, it would account only for 16 of the 77 acres that was alienated here, all of which had been a parking lot. Finally, with respect to his reliance on the phrase appurtenant, again, it doesn't appear in
I'm
the
sorry, I didn't follow that. What is the number of, what does the acreage have to do with
If
it?
you look at subsection C, right,
Okay.
that subsection alienates 77 acres of land.
Yes.
Shea Stadium took up 16 acres. And so the only coherent way to understand the statute is that the legislature had in mind that most immediately Shea Stadium would go on 16 of those 77 acres, and that the city would have the discretion in the future to decide on how the remaining 60-odd acres would be used in a way that was consistent with the broad purposes set forth in subsection B. Purposes which
Whether
are
or not it had anything to do with the stadium. Is that what you're saying?
absolutely, Your Honor, and that's again where the Yankee Stadium statute stands apart, and where the second sentence in Section A stands apart,
And
because
why,
it doesn't
then why would
reference-
it have conferred that property, all of that property, if it wasn't meant to be related to the stadium?
The best answer, I think, from the record is the historical context. The entire swath had been operating as a parking lot. And so rather than take 16 of those 77 acres and say, okay, we'll put Shea Stadium here and we'll alienate that, they alienated the entire swath of land, presumably because they believed that the city could identify
So
productive
there's
uses
nothing in the
down the road.
history that tells us, we're inferring that.
The best signal is the one that my colleague from the state identified for you, which says that the purpose is for the establishment and maintenance of facilities for recreation, entertainment, et cetera, not just a stadium. So even the bill jacket itself does reflect that.
I'm sorry, Chief, may I?
Yes.
Just to go back to the public trust doctrine
Yeah.
for a minute, because I think it is really what will move forward from this case, what people will look at. And it seems you're framing this as two very different approaches to the public trust doctrine. Under what I understand your approach is based on the cases, Gallup and the others, is you look at plainly conferred in the initial sense of, did you plainly confer this land to build a stadium? But in terms of the language of how far that goes, in terms of what you can use the land for in addition to the stadium, it's purely statutory construction.
Well, I think that's what your own cases in Bates and Brooklyn Park suggest, but I think that your point gets to an additional question, which is there any problem when the legislature alienates land for non-park uses in devoting it to a broad range of purposes as opposed to a very narrow one? And
Different question. My question really is, do we apply the public trust doctrine in what I would consider a heightened scrutiny, or looking at it in terms of this plainly conferred, meaning we're not going to expand the language, only with respect to the purpose for which it was conferred? Or do we look at it in terms of this language? So your view, as I understand it, is we don't apply the plainly conferred standard to this provision, because plainly conferred only applies to Shea Stadium.
Well, I think that even if you apply the clear statement rule that Mr. Lobier is proposing, that it is satisfied here. But I would also say this. What the court would do if it announced a rule like that, which is that it will, I'm not even sure exactly what the canon is, but as best I can understand it, there's a strong presumption against doing anything, and the legislature not only must identify the tract of land, which it's done here, must identify the intent to use it for non-park purposes.
I think it would be, if you're going to alienate it for non-park purposes, you're going to read narrowly the non-park purposes that it's been alienated.
And that would tie the legislature's hands in a way that has no relationship
But they're
to
the legislature, they
purposes.
can make whatever statute they want. How could it tie their
They
hands?
can, but it would deprive them of the ability to do exactly what they did here, which is to take a large tract of land that, while designated parkland, is functioning as a parking lot.
But I don't,
and
why
say-
couldn't they have said in this, you can use it for any commercial purpose?
Well,
I mean, what would
because they
prevent them from
wanted,
doing
they
that?
wanted it to be used, and B1 insists that it be used for broad purposes, but purposes that benefit the public. And our point is
Does
that
it speak to that some of the petitioners here are in fact legislators? I mean,
obviously, they're free to take whatever position they have. The
but I
question
mean, if
before
you're
this.
saying that we shouldn't do this because it'll tie the legislature's
Yes.
hands, it just seems to me that the fact that some
Well,
of
the
the
question
petitioners
before-
are legislators might be an indication that that's not their concern here.
Well, I would disagree with that in two respects, Your Honor. First of all, the fact that there may be a few legislators who have joined any litigation, I don't think is probative of the legislature's intent as a whole. But secondly, the only question before this
I guess
court.
all I'm suggesting is that aren't we really speculating about that? I don't see that there's any indication from the legislature that is the concern, that is a concern here.
What I'm I guess I'm
Oh, but if we
suggesting-
disagree with you, there's nothing, that would not foreclose the city from going back to the well, correct?
It wouldn't, but Your Honor, that's exactly the concern here. We obviously believe we do have legislative approval, but there have been efforts by folks no less formidable than Robert Moses for 100 years to remediate Willets Point. In 2008, the city put out a proposal to do that. There were no takers. This is
So
the
if
last.
the legislature thinks that's important and this is the way to do it, then if we disagree with you, again,
and
piggybacking on what Judge Rivera is saying, then they can do it and make it even more clear.
And, Your Honor, what 2008 shows is that a proposal that looked viable in 2008 when it was issued became completely infeasible a couple of months later when the economy tanked. And so there is an agreement on the table.
That's also true about them all.
Pardon me?
That's also true about them all. I mean,
Your Honor,
the hopes of
this-
what will come of this are not certain either.
I would just close by saying this if I can. This project is important, not just to the city, but to my clients, because Willets Point, as contaminated as it is on the front door of the Met Stadium. And so they have every intent of moving forward with this project as soon as they can. Thank you.
Thank you.